On to Mr. Raya for 5 minutes.
Thank you, Madam Chair. Mr. Mark Warner, thanks a lot for bringing out the history of these mechanisms and emphasizing the importance of this mechanism in depoliticization. That's a very excellent point many of us forget. And also twice, you mentioned we are becoming a capital exporter. The capital export is still growing. And Mr. Lawrence Harman, I did read the note that you circulated, and I have to state, let me just quote the last para of your note. You mentioned the need for modernization to make the ad hoc arbitration process more efficient and effective and consistent. That is very, very important. You also touched on state-to-state obligations. Once again, many of us forget of that. The foreign investment protection and promotion agreements are a fact of life today. We are, the Canadian companies earlier in the previous generation, I can say it was few mining companies that were investing abroad. But these days, a lot of Canadian investment is going from the Canada Pension Plan or the OMERS or the TTS pension, and we have been investing elsewhere. To take a specific example, Canadian investments in India is about $52 billion. And we don't have a FIPA yet. We don't have any foreign investment protection agreement with India. So what is the mechanism available for Canadian capital exporters to protect our investments? Many times, just because few Canadian mining companies acted in a wrong way to brush everybody with the Canadian companies are bad actors is something I don't agree with. I think we need to have a mechanism where the funds of an average Canadian that is invested through our pension plans, whether the CPP or OMERS or teachers, what is the mechanism available when they invest in Asia and South America? For example, in India, where we don't have any production agreement.
Are you asking me,
yes,
Mr.
Sir.
Are you? Well, when it comes to India, we don't have a FIPA, and so there aren't any state-to-state obligations that Canada could rely on. It would be up to in that case, the investors to assess their risks and to make decisions accordingly. That's just the way the market works. Some people say that investment protection agreements unfairly, I guess, one way of expressing it, unfairly underwrite investor risks, and that it's up to the investors to make the decisions of whether they want to invest in a particular jurisdiction. But to answer your question, there would be no way in which an investor in, let's say, India could be protected other than recourse to Indian law in the event of some behavior that was illegal or improper. So that's the short answer to your question regarding India in particular.
So we have a practical case here. When Canadian investment, when I say Canadian investment, I'm talking about some mining company investment. When an average Canadian like you and me, our investments through our pension plans get invested in various countries because we need to invest in other countries to generate returns for our pensions. So when we make investments in countries in South America or Asia, doesn't that emphasize the need for having these investment protection agreements?
Well, in my view,
short answer, Mr. Herman.
In my view, yes, it does. But those agreements can be drafted accordingly, provide the necessary guarantees and protections for the host country, vis-a-vis the investor that we talked about, but would also give the investor a framework for bringing action if that investment was unfairly treated.
Thank you, Mr.